Earlier this week, Parliament passed what's commonly known as the Anti-Protest Bill. It's this one here. It's called the Summary Offences and Sentencing Amendment Bill. It still needs to go to the Governor for royal assent, so it is not law as yet. And so this bill shouldn't impact on anyone at the march in March this weekend, but it does make sense for people to understand the changes. First off, the section that is being changed is Section 6 of the Summary Offences Act 1966. It's not the only section that's being changed, but it's the one that's of interest to people as far as protest goes. So that's called the direction to move on, and basically what it means is that a member of the police force or a protective services officer who is on duty at a designated place can give a direction to a person in a public place to leave that public place. And currently there are 3 circumstances under which they can do that. One is if they believe on reasonable grounds that the people are breaching or likely to breach the peace, or that they are endangering or likely to endanger the safety of another person, or they believe that the behaviour of those persons is likely to cause injury to a person or damage to a property, or otherwise a risk to public safety. The anti-protest bill will add an additional 5 or 6 circumstances where you can be asked to move on by a police officer or a PSI. Clause 2, a direction under this section may be given orally. The only change that's being made to that is that it will specify that it can be given to a single person or a group of people, and sections 3 and 4 will be staying the same. So a direction under this section may direct the persons or persons to not return to this place for a period of not more than 24 hours. And subsection 4, a person must not without reasonable excuse contravene the direction. So if you don't leave the place, you can be fined an amount equivalent to 5 penalty units, which I believe from what I've been seeing in the newspapers is about $750. Subsection 5 will be undergoing fairly significant changes. At the moment, what subsection 5 says is that this section does not apply in relation to a person who, whether in the company of other persons or not, is picketing a place of employment or demonstrating or protesting about a particular issue, or speaking, bearing or otherwise identifying with a banner, placard or sign, or otherwise behaving in a way that is apparently intended to publicise the person's view about a particular issue. So basically what this says, if you're protesting, demonstrating, none of the above applies to you. That's what is about to change. There's also subsection 6 that will be added to this section, and they're the only changes that are taking place to existing legislation. The rest of the legislation that's coming in relation to the anti-protest laws are all brand spanking new. To make it as easy as possible to understand the changes that are taking place, I've put together a document that shows what the new legislation will look like when it goes into place. So we're already familiar with section 6 because we've just looked at it. Here's the first clause. A member of the police force or protective services officer on duty may ask a member of the public to move on. These are the 3 circumstances that we're familiar with. If you're breaching or likely to breach the peace, if you're endangering or likely to endanger the safety of another person, or if you're likely to cause injury to a person, damage to property or otherwise a risk to public safety. And these here from D to H are the new circumstances under which you may be asked to move on, and that is if you have committed an offence within the last 12 hours, or if you are causing a reasonable apprehension of violence in another person, or if you are causing or likely to cause an undue obstruction to another person or traffic, if the person is present for giving or receiving drugs, or the person is impeding or attempting to impede someone from leaving or entering a premises. Okay, item D seems to be one that's drawing quite a bit of ire, just simply because committing an offence may be something as simple as jaywalking or littering, for example, dropping a cigarette butt. Subclause 2, as I indicated earlier, that was just going to be changed to say that it could apply to groups. So now it reads, a direction under this section may be given orally and may apply to an individual person or a group of persons. 3 and 4 remain unchanged. So 5 and 6, these subsections are the ones where the major changes are taking place. Now, in the previous version it said that if you were picketing or demonstrating, protesting, or in any way trying to express your view about a particular issue, then none of this applied to you. Well, that's all going to be out the window when these changes come in, and the only time which it won't apply to you is if you're breaching the peace or you are causing an obstruction. They're the only circumstances that will not apply to you now. All other circumstances will. So this is part of the reason why this new bill is seen as the anti-protest bill, because there are so many circumstances now where you can be asked to leave a protest and not return for a period of 24 hours. And that could be jaywalking, that could be dropping a cigarette butt, or any other number of circumstances as we described earlier. Section 6A is a totally new section, and the gravity of this section is that when this bill does become law, when it goes live, it means that if you don't respond to an order, a direction to move on in a timely manner, in the past you would get a fine. When this goes live, you can be physically arrested, and you can be arrested by either a protective services officer or you can be arrested by a police officer. If you are arrested by a protective services officer, they're required to hand you over to a police officer as soon as possible, and that police officer shouldn't hold you in custody any longer than is absolutely necessary, but there are circumstances where they are allowed to hold you in custody. So if they want to ensure that you appear before a court, or they want to preserve the public order to prevent you from continuing or repeating an offence, or if they consider your safety or someone else's safety is at risk. And subsection 4 just simply states that if it appears that it's no longer necessary to detain you, then you must be released. Just to sum up, when this legislation goes live, if you're given a direction to move on by a PSO or a police officer and you don't do so within a timely manner, they will have the authority to arrest you. Section 6B is another new section, totally new piece of legislation, and this is about the requirement to give your name and address. If a member of the police force intends to give you a direction to move on, they may ask you to state your name and address. If they do ask you to state your name and address, they have to advise you that they intend to give you a direction to move on, and you must comply and provide your name and address. If you do not, or if you provide a false name and address, you can be fined 5 penalty units. Now, just 2 points I want to make before moving on. This only refers to a member of the police force, so it appears that PSOs will not have the authority to ask for your name and address in relation to a direction to move on. So that's different to if you're on the train and you're caught without a ticket. That's a totally different situation. But if it's in relation to a direction to move on, this legislation doesn't seem to give them the authority to ask for your name and address. And the other thing to remember is that this only applies once this legislation goes live. As subclauses 4 and 5 relate to your rights in relation to if a police officer asks you to state your name and address. You can ask the police officer to state orally or in writing their name, rank and place of duty. They are not allowed to refuse to comply with your request, and they must provide those details in writing if you ask for those details in writing, and they cannot provide false details, and they're also subject to a penalty of 5 units. For those going to the March in March in Victoria this weekend, I would be inclined to keep these clauses in mind, and if you are asked for your name and address in relation to a direction to move on, I would ask the police to provide their details in writing, have my mobile phone handy, and take a happy snap, because I don't believe this legislation is live yet, so I don't believe they have that right as yet. However, do keep in mind that the idea is to have a peaceful protest, so if you are asked to move on, I would move on, but before moving on I would get the details of the police officer and I would take a photograph. And keep in mind, I'm not a lawyer, I have no legal training whatsoever, I'm just someone who has wanted to get a better understanding of what's going on, so I've done some Googling and this is the information I've found, and so I've put it into a video. Subclauses 6 and 7 concern me because basically they say that if you're asked to give your name and address and the police officer doesn't believe you, you must provide proof that that is your correct name and address. Now this concerns me because I'm frequently walking around without any ID. I don't typically take my driver's license with me when I catch a train, for instance. There's no reason to. And you are required to comply with this request, and if you don't comply you can be fined 5 penalty units, which again I think is about $750. And so basically I interpret the ramification of this as being, if you jaywalk and you're not carrying ID, you can be fined $750 once this legislation goes in. Subsection 8 just simply states that it's not an offence if you fail to comply with a request to supply your name and address, if you're not advised by the police officer that it is an offence to fail to comply. So in summary, the requirement to give your name and address in relation to a direction to move on is a new requirement with this new legislation that is coming in. Division 1B is a whole new division that will be coming in when this legislation goes live, and it's about exclusion orders. I'm actually going to skip most of this section and just focus on the bits that I think are most relevant, because there's a lot of material here and I don't want to overcrowd our heads. So basically what an exclusion order is, it's an order made by the Magistrates Court that says that you can't enter a certain public space for a period of up to 12 months. Section 6E outlines the circumstances under which an application may be made to the court for an exclusion order, and this is really quite disturbing because, to start with, it says the order may be made if the court is satisfied on the balance of probabilities. Well, to me that sounds like innocent before being proven guilty is thrown out the window. It's just if they reckon that this is what's happened. So an exclusion order can be taken out against you if you have been given a direction to move on 3 or more times within a period of 6 months, or 5 or more times within a period of 12 months. The thing that's important to understand here is that it's not if you've refused to move on 3 times within a period of 6 months. It's just if you've been asked to move on 3 times within a period of 6 months, or 5 times within a period of 12 months. So I interpret this legislation as having all sorts of nasty ramifications. To start with, for instance, let's say you're part of the Occupy movement, and the Occupy movement as a group, they've been asked to move on from the city square half a dozen times in the last 6 months. Then the court may consider that based on the balance of probabilities that you've probably been part of that group, so they may potentially order an exclusion order against you just simply because of who you associate with. So summarising very briefly, The exclusion order will be coming in with the new legislation, and it's a totally brand new piece of legislation in relation to the direction to move on, and it could exclude you from being in a particular public place for a period of up to 12 months. And now we come to the part that everyone's been talking about. When this legislation comes in, it will indeed be possible for you to go to jail for 2 years for protesting, because if you contravene an exclusion order, the penalty is 2 years imprisonment. But it does not appear that there's any way where you could be jailed for 2 years for a single protest. But if you're part of an ongoing movement and they ask you to move on a regular basis, then you face the real possibility of going to jail for 2 years. So it's my firm belief that as at this date, the 14th of March 2014, this legislation is not yet in place. And if I've misunderstood something, and it is indeed already in place, hopefully this will give you a better understanding of how the legislation operates. It would appear to me that at this point people in Victoria are safe to attend the March in March without any fear of being imprisoned for 2 years. However, I do consider that this is a very nasty piece of legislation, and when it does come into effect, it will drastically reduce our freedoms of speech, of movement,